Hi, I'm Apoorva. I am the founder and director of Animal Law and Policy Network Research Foundation. I know that's super long. That's why we call it ALPN Research Foundation. I'm the founder and director of this organization. We are a think tank. We started about 10 months ago. We're based out of India in a place called Bangalore. And we work on animal law and policy issues. We're currently doing a lot of policy research on issues related to animals, particularly farm animals. Now, the topic that I'm going to speak about today is a critical examination of the role of constitutional courts in the development of animal law in India. Yes, I love law. The reason I decided to focus on this issue is because India is a common law country, and in common law countries, courts have a lot of importance, and they play a critical role in how the law is shaped and how it develops. And having worked in judicial reforms before this, and having worked as a court reporter before that, I've observed courts from up close, and I think I have a nuanced understanding of how they function. So I wanted to see how courts are doing with animal law in India. Before I go into the details, there's going to be a lot of context setting as part of this presentation, because I understand that a lot of you may not be familiar with what is happening in India. So there are a few caveats that I want to start with. This is a work in progress, firstly. There are going to be lots and lots of unfamiliar names, but I will try to make it as easy and as short as possible. There are hundreds of judgments on animal law in India, because animal law itself is a very broad topic. So we haven't covered all the cases. We're just looking at some illustrative cases in certain categories. As I said, there's going to be a lot of context setting. I wanted to start with a brief overview of what the Indian judicial system looks like. We have a Supreme Court in the center, which is which is the highest court of the land. It is the constitutional court, which is also responsible for enforcing fundamental rights that are given to us by our constitution. Then we have high courts in different states. We have 25 at present, and we have about 29, 30 states. So some states do share a high court. And then we have the district courts, also called the subordinate judiciary. But for the purpose of this study, we're focusing on the Supreme Court of India as well as the high courts, because they are what constitute the constitutional courts in our country. Now, what makes the Indian judiciary so unique that I thought it's an issue worth studying? So in India, we have something called the public interest litigation. Now, this is something that arose in the 1970s and the 80s, when the Supreme Court of India realized that they needed to dilute the doctrine of locus standi, because not everyone was able and had the resources to approach the Supreme Court for addressing their grievances. Since the Supreme Court is the primary enforcer of fundamental rights, it also had to make it accessible for people to enforce those rights. So the Supreme Court diluted the doctrine of locus standi and allowed individuals and organizations to approach the court on behalf of other people who could not come to the court themselves. As you can see, this might open roads for animals to be brought in. And that's something we will discuss. And PILs have played a very important role in the development of animal law in India, and that's something I will discuss as we go ahead. One thing I did want to, again, part of context setting, there are three main types of provisions in the Indian Constitution. We are talking about constitutional courts. We have fundamental rights. We have our directive principles of state policy. Now, these are basically directions to the state governments and the central government about what sort of laws they should make. So, for instance, we have Article 48 as a part of the directive principles of state policy, which allows states to make laws prohibiting slaughter of cows. We have Article 48A, which allows states to make laws concerning protection of environment, forests, wildlife. And then we have our fundamental duties, and this is what makes the Indian Constitution slightly more advanced of other constitutions. At the time this was enacted, which was in the 1970s, this amendment came in. We introduced a fundamental duty for all citizens of India to protect and improve the natural environment and to have compassion for living creatures. Now, this is a fundamental duty of all Indian citizens, and this has been called in some cases the Magna Carta of animal rights in India. Now, Another thing that's often ignored in the Indian context, when we do talk about India, there's this one case that came out 10 years ago. It's called the A. Nagaraja case, and I will be talking a lot about it. But it's almost thought that animal law jurisprudence began with A. Nagaraja. That's not true. That's actually far from true. Because there was a lot of environmental law jurisprudence that was already developing in India from the 1980s, 1970s, after the enactment of our environment protection laws, which actually shaped a lot of interpretations in animal law cases at a later point of time. So again, I'm not going to go through all of these cases. There are too many of them. But essentially what they're trying to say is, so fundamental rights enforceable, fundamental duties not enforceable. Directive principles of state policy, which are directions to the government about how they should govern, kind of enforceable. They're not technically enforceable, but they have to be read harmoniously with fundamental rights. So there are this catena of judgments which talk about how directive principles of state policy, which, as you may remember, talk about protecting laws to protect environment, wildlife, etc., have to be read with the fundamental duty of having compassion for living creatures, right? And another thing that happens in the environmental jurisprudence is that the courts go on to read our fundamental duties in a sense that it is not just the fundamental duty of a citizen. Since citizens together form a state, the state thereby has the duty of having compassion for living creatures. Right? I mean, that's the extension I'm making, but they've applied it in Abhilash Textiles and in LK Kulwal to the environment. So they've read the state as a collection of citizens and thereby a holder of fundamental duties as well. So there is a lot of development in environmental law jurisprudence, and the latest case that we've had talks about how Indian citizens have a right against the adverse impacts of climate change in India. Based on our fundamental rights. So this jurisprudence goes on to feed into some of the landmark cases on animal law. Now, there are 6 areas that I'm focusing on. There are many, many more. These are just areas of interest to me, areas that I have studied, and also cases which really illustrate the point that I'm trying to make here. So I will not go through the details of each and every case, but I will talk about them and refer to them in the discussion towards the end. First, in 2000, in roughly around 2000, the Indian government decided to ban certain types of animals in circuses, specifically bears, monkeys, tigers, panthers, and lions. And this was appealed, and in this case, it was held that legal right, again, it was observed, it was not held. This law was upheld by the court, but it was said that legal rights should not be the exclusive preserve of humans, and it has to be extended to non-human animals as well. So this was one of the landmark cases which is not as talked about as Nagaraja, because A. Nagaraja is the most talked about case. Now, A. Nagaraja deals with this bull taming sport that is prevalent in certain parts of the country, particularly coastal areas in the state of Tamil Nadu in India. And this is considered a landmark judgment because this is a division bench judgment of the Supreme Court of India, where they extend the species, they apply the species membership approach. There is a lot that happens in this case, but essentially they say that the Prevention of Cruelty to Animals Act in India extend the duties that it imposes on the owners or the people who are in possession of the animals. Essentially, those duties confer certain right on animals. So the imposition of duties on human beings by the law, confers statutory rights on these animals. And the court looks at ethology. It constantly talks about right. It also talks about the doctrine of necessity. It talks about how we need to it's okay, it's acceptable that animal interests are subservient to human interests. So the animals' life can be taken away to protect for the welfare, for the benefit of human beings. But it still is considered one of the leading judgments on animal rights in India because it it said that animals have statutory rights. Now, this judgment was not entirely overruled, but it was appealed, and the Constitution Bench of the Supreme Court of India recently, in 2023, held that this sport could be conducted. Now, but it did not overturn the key principles that came in the A. Nagaraja case, the species membership approach, the five fundamental freedoms. So, what has happened here is, and this is exactly why we need to study the role of courts, because what happened here was, as soon as the A. Nagaraja judgment came out, there were protests all across the state of Tamil Nadu. People said that the courts were impinging on their culture, their heritage was in danger, and that led to the state government passing a law which was then approved by the center, and basically they nullified the judgment. That was there. But then the Supreme Court, when it was considering the Constitution Bench case, did not do anything to save the save the judgment that two judges of this court had earlier passed. They agreed that, so it's a very interesting judgment, the 2023 judgment. If you read it, you will see. What the Supreme Court is essentially saying is, yes, A. Nagaraja was true when it was passed. Like, it was absolutely correct. Their finding that bulls are subjected to immense amount of cruelty was absolutely true. But look, now the government has passed these laws and there's no more cruelty. Bulls are happy, contained in this sport. So basically their argument is, once a law is enacted to curb a problem, that itself is sufficient to say that the problem has been resolved. So, I mean, that would be so cool, right? Like, laws passed. So, basically, if we had a law banning child sexual abuse, if that law is passed, does it mean that child sexual abuse has stopped? It hasn't, right? It would. So that is. So it just shows how the Supreme Court was not really open to arguments at this point of time, and it also says certain damaging things in this judgment, saying that rights is not a question for courts to determine, damaging for the animal advocacy movements. Then another inconsistency in approaches I want to highlight is through these three cases, which is on the issue of animal sacrifice in temples. Now, certain states have banned animal sacrifice in temples. In Ramesh Sharma versus state of Himachal Pradesh, it was banned in the state of Himachal Pradesh. In Gauri Maliki, they had a very interesting argument. They said, yes, animal sacrifice cannot be done in urban areas, but in rural areas it can be done as long as the food is used for human consumption. So as long as you're eating the animal, it's completely fine to sacrifice them in a temple, but otherwise it's not permissible. Now, Subhash Bhattacharya was a case in the state of Tripura where the court banned animal sacrifice, and this also is something I will discuss. It was later stayed by the Supreme Court of India because it was just unfathomable in the state of Tripura that there would be certain temples where animal sacrifice could be banned. And this judgment also misinterprets the A. Nagaraja judgment that I was talking about, and that is due to the certain fallacies with the A. Nagaraja judgment. And then the Supreme Court was actually approached by a journalist saying that we should just ban all animal sacrifice in India. It should just plain blanket be banned. And the Supreme Court actually, in an oral observation, said, no, we're not going to ban animal sacrifice. This is part of our culture and tradition. And we just cannot have a blanket ban on animal sacrifice in India without even entertaining that tradition. So that is how different constitutional courts are dealing with this one issue. So everyone has a different way of dealing with it. Another judgment which is very interesting is Maya Chablani versus Radha Mittal. Now here the Delhi High Court recognized that stray dogs, and we have millions of them in India, have a right to food. And it gives no legal basis on where this right is originating from, who is responsible. And one thing that courts often do in India is they resort to the doctrine of parens patriae by saying that it is the state that is responsible, but somehow in the process they also make all citizens responsible. And they do not talk about how it is supposed to be enforced. And then I've also looked at the issue of captive elephants, where in the case of captive elephants, there was this one case, the Veeramani Chettiar case, where the Kerala High Court has actually said that the Constitution, and it said that in very clear terms, the Constitution of India gives rights to human beings, it gives fundamental rights to human beings, and those rights trump all other laws. So in this case, an elephant was shot because it was on a rampage, and the police officer was brought to court. Okay, I will be quick. And then there are judgments that say birds have a right to fly. And this is really difficult to understand when we have farming, especially battery cage, the prevalence of battery cages at such a large scale in the country. There are and then there are judgments, there are two judgments by the same judge in different high courts which say that animals are legal persons without any basis. I wish there were a legal basis, but there isn't currently. So what are our preliminary findings? Firstly, there are implementation challenges. That's an easy one. I mean, this is understandable. If there are going to be judgments, there are going to be challenges to their implementation. But then there is a lack of consistency and clarity on the judgments on the same issue from different courts. So as we saw in animal sacrifice, one high court is saying ban it. One is saying as long as you eat it, it's okay. Supreme Court is saying no, this is cultural, we can't ban it. The Tripura High Court in the actually animal sacrifice case interpreted the right to life as applying to animals. So, and that brings us to the next point. A lot of judgments in India are biased by the judge's personal opinions. And it is, even in the animal sacrifice judgment from the Himachal Pradesh High Court, the judge makes this really long statement about how no religion wants animals to die for its sake. And it would be unfathomable for the founders of these religions that animals were killed for their sake, etc., etc. So, which brings me to the next point, that it is often impossible to distinguish what is the ratio of these cases and what is the opposite. Because they say so many things so casually that it is very, very difficult to understand what the real finding and the conclusion of the case was. There's utter confusion about core concepts like rights and duties. So animal rights is just thrown around as a term without having any substantive meaning. There are also some peculiar Indian problems. I think since the goal of this paper was to study this because litigation is often very heavily relied upon by the animal advocacy movement in India as a tool to bring faster change for animals. So the goal of this exercise was to see whether it is an effective tool. So what we found was sometimes the litigation has not been as strategic. Say in the bull taming case, an easier win, an easier argument that could not have been countered easily would have been to say people also die in that sport, than to make it an animals versus humans issue. Now that is a strategic decision, and a lot of us in hindsight think that it could have been done differently because there are too many people who die in that sport every year. And it would not have then been framed as a humans versus animals issue. Then there are the dangers of judicial adventurism. Activism is an accepted part of how the Indian judiciary functions, but adventurism is a whole new realm. As a judicial reforms researcher, I am concerned that if today they're creating laws and not interpreting them, then one fine day they may say things which we don't want them to say. Today it's convenient, it's good for the animals that they say animals are legal persons. But what if tomorrow it's very easily, it's not sustainable change that comes from the judiciary. And last is really cryptic language. We throw around words too casually in our judgments, and which makes them possible. Like the Jallikattu judgment that I've been referring to has been misinterpreted by so many courts in India. So these are high court judges who are saying that animals now have fundamental rights under the Indian Constitution. They have a fundamental right to life under Article 21, which is not what the judgment says. But the judgment has been worded in such a manner that it leads to that conclusion. I would say our preliminary conclusions are that I think we need to be more strategic in the kind of issues we choose to litigate as a movement, as the animal advocacy movement. Uh, Even within these issues, um, the cases which have actually stayed and not been overturned and have not caused too much furor are cases where the government passed a law, the law was challenged, and the court just upheld the law. The problem cases are where the court is expected to overturn government laws. That's where the change is not sustainable. And yeah, the conclusion is that Indian constitutional courts are very, very actively engaging with animal law, and that has a very, very important signaling effect. But we shouldn't try to read more than what there is in these judgments. Sometimes they're just a judge's opinion, and I think we need to understand that and take these judgments with a pinch of salt, because often they don't lead to too much concrete change on the ground. And those are my facts. Thank you.